they can pick up the recording. So welcome to all the coaches for our coaches meeting. My name is Taylor Rex Robinson. I'm one of the vice chairs on the committee. I am standing in for Steve Gwynn, who had kind of a conflict that came up at the last minute. I'm joined by Allison Rapond, another vice chair on the committee. And so we'll be going through a coaches meeting just as an overview. I'm going to show you as the coaches the slide.
Don't hate, Brian's here. I had a call in since Allison booted me and IP blocked me.
We also have
Brian me like a bug.
We've told Brian
I'm here by a phone.
That's how we're going to kick him out of the committee, is by kicking him out of this group. But what I'm going to start with is the PowerPoint kind of slideshow that we show the judges in their meetings prior to competition, just so that you as coaches know pretty much what we tell the judges. This is from last year, so I'm going to skip over the analysis. We'll do a bench brief for the judges of the case. I don't share that with the coaches in any event, so I'm not hiding anything from you, but because it's a bench brief in our summary of the case, we exclude that from the coaches. If you have any questions during the process, feel free to put that in the chat, and I can stop and answer that question. You can either type your question in the chat box or just say you have a question, and I can call on you and we can discuss then. Then once I do the PowerPoint slide, I'll give you just a brief overview of kind of where we are in the process with respect to the virtual competition, which I'm sure you know, but it will be virtual this year. And then I'm saving the bulk of the time to answer questions that I'm sure many of you have. So we'll start with the slideshow that would be shown to the judges. Again, this is for all the judges that would be scoring or presiding. We have basically a meeting before every competition. So many judges hear this 6, 7 to 10 times over the course of the competition. But this gives you an idea of what we would be showing them. So the first thing, we tell them all to silence their cell phones, one for distraction, and reminding them that no electronics are allowed by the students in the well. And again, that would be the same again for this year. On this note, let me just stop real quick. So you're probably gonna have a ton of questions about the virtual nature of the mock trial. We are still working through some of those issues. So I don't have definitive answers on a lot of that yet. I can tell you what we are anticipating with respect to some things, but there will be a meeting at a later date to describe and really kind of firm up the rules with respect to, what people are in what rooms, how many cameras do you need, how can people communicate, et cetera. Again, I'm happy to give you insight about where we stand on some of those, but we don't have that finalized. So just as a brief overview. We then walk the judges through the score sheet. We explain them that there's 11 boxes, totaling from 10 down to 1, and how they pick the better presentation, totaling up scores. We explain penalty points, and that they must provide us a description of what happened on the back of the sheet in order for us to award the penalty point. Often these are then discussed with us. Oftentimes they'll think, advocate didn't do a good job of cross, and that's a penalty. And we explain, no, that's the points for the students. And so that's usually that process there. We also explain outstanding witness and advocate. We explain to them kind of the rules on how to judge it and the setup: 3 lawyers per team, 1 opens, 1 closes, and then all 3 have individual directs and crosses. Also 3 witnesses per team, and they must be played by different students. We don't allow whoever your theater superstar is to play all 3 witnesses. We explain to them that objections stop the time. And one of the reasons is so they know that they have freedom to allow some objections and responses back and forth if they wish, and that the timing itself, the process of that it goes during their time that their lawyers are speaking, as well as opens and close, and how to note the timekeeper if there's any discrepancies, etc. We explain to them the rules. All teams are identified only by letter. They should never tell you what their school is, and the judges should never ask. We also explain to them the no scouting rule. Every person in the, back in the day in the actual courtroom must be affiliated with one of the 2 schools because there is no scouting. and that there is a strict wall of communication over the rail. This includes verbal and nonverbal communication, whispering, note changing, as well as, of course, electronic communication. We talk about cameras, that if a side wants to record, they must get the approval from the other side. If they don't, then they can't record it. We tell them to be on the lookout for parents in the back that kind of hold their phone up when their kid is giving a cross or an open, and that we must take those videos until the end of trial, because that alone could be served as scouting. And then we dive into the specifics of each box where points are awarded, 11 total for 3 crosses, 3 directs, opens, and close, as well as 3 witnesses receiving their own scores. Only whole numbers from 10 to 1, and it would total up to 110. We then talk about what witnesses should be scored on. This is not only understanding of the fact pattern, confidence as their character, but also embodying the character themselves. If the example is often given of a student who played some very technical scientist, doctor on the stand and was perfect, and then came off the stand, sat back in his chair and started playing with his tie like a kid. So we tell them to watch the witnesses throughout the course of the trial. Are they maintaining character? We also explain to them to be on the lookout for witnesses that refuse to answer the questions, especially when they are warned or instructed by the judge to answer the question if they have been refusing or long-winded. We explain to them there is to be on the lookout for witnesses trying to waste time by giving long, rambling answers, so that they are on the lookout for that. Again, scoring was in whole numbers. We tell them to start high and work low. The example is often given of writing 6, 7, 8, 9, 10 in a box. You see something that's not a 10, you scratch off a 10. You see something better than a 6, you scratch off the 6, and eventually narrow your way down to the correct score. We tell them to generally avoid scoring below 5 and 6, and that teams that typically receive 8s and 10s move on, and teams that receive 6s and 7s do not. The purpose of this is just to normalize everybody's scoring, such that one lawyer that's being a scoring judge somewhat forgets that these are high school students and scores everybody's in 6s and 7s, and explain to them that ballots and points are very important for schools. And so for them to normalize those as best as possible, and indeed telling them, remember, they are high school students. We then reemphasize that it is a direct, cross, redirect, recross, and stop. Do not offer them the opportunity to do redirect, because the students will take it, and they should if they're offered, but to limit it to just those 4. We then provide them this explanation of the score sheet and what generally the points reflect. So you will see some explanations. I always reiterate, these are not firm. I have seen plenty of very polished students that seem to have the whole fact pattern memorized, but then fail to conduct any effective cross-examination. So the mere point that they stand up, they don't use any notes, is not an automatic 10 or 9. And similarly, you'll see even under 6s and 7s and 8s, seldom refers to notes. If an attorney, certainly in practice, rarely do attorneys use no notes, but that these are just general guidelines. If they think the student is using a small outline, as opposed to just reading questions that have been prepared, they are not restricted from providing them 9s and 10s. And you'll see they rely heavily on notes, not exclusively rely on notes, seldom refers. We use that just as an example. But again, they are not tied to those. Just by using notes does not forbid them from receiving a 9 or a 10. We explained to them this is an advocacy competition. You're scoring them on the advocacy, not the merits of the case. We take great lengths and a lot of efforts to ensure the fact pattern is even. But to the extent it is not the student's fault. Just because the lawyer sitting in the scoring judge's box believes there's no way murder could be proved, or there's no way the defendant would ever get off, doesn't matter. They are only there. The students have been given a limited fact pattern, a limited universe. It is to judge them on the advocacy of using that closed universe. And they cannot invoke the rule to exclude witnesses from the courtroom. Everybody's in the courtroom together. We also tell them it's preferable that they don't teach the students at the end of a trial. Many of you probably tell them not to listen to the judges, and we tell them that. I know that I was told that when I was in mock trial. And so this also keeps the process moving along, because if they miss things, they miss things. Again, the penalty points, they must be given a reason. And if they fail to give it, we won't award the penalty point, but there is also a discussion usually about what occurred to ensure that it is not, just bad advocacy or something that actually wasn't a penalty at all. But this is, again, solely up to the scoring judge's discretion. So long as it's not, bad advocacy, we tell them not to use that penalty point, but they get to determine whether there is one and how much. It is possible, and it has happened, where 2 judges find penalties and 1 does not. Again, it reflects the individuality of the scoring judges. Again, best witness and best advocate. Explain they don't have to be from the same team. They don't even have to be from the winning team. And they do not have to agree. Again, there's the outstanding witness and advocate. We tell them that we really want them to write it by the name of the student, the character that they're playing, and the team. This just helps us in case there is name similarity. There's often siblings at schools, because if we just get Smith, and we have to spend a lot of effort to try and figure out which student is being awarded that benefit. We explain to them that you all are provided these team rosters. They are indeed fillable PDFs, and we recommend strongly that you type them so that they are legible and that they are clear. Oftentimes when they are handwritten, it is very difficult to read a student's handwriting, and that slows the trial down. Again, we ask them that they fill it in as opposed to that, because that makes it very difficult to figure out who they are, and especially for awarding best advocate and witness, because they will refer back to that score sheet. Again, we tell them to put the highest team that scores the most points, and that it is not, oftentimes judges will think at the end of the trial, well, the plaintiff really killed it, and then when they add up their scores, it turns out to be the defendant, or certainly vice versa. We tell them that's demonstrating they were judging on advocacy, probably not on the merits. But we tell them there can be no ties. If there is a tie, they alone have to figure out where to add a point or where to subtract a point, and then they sign. Post-trial procedure, tell them to ask again, is there any rules violations from either team? To complete the score sheets, assemble the packets, roster forms, response forms, this box here that confirms the number of ballots for prosecution defense, the better presentation, and then their contact info, just in case we later discover that there is an error or discrepancy, so we have the ability to contact them. We double check, we then release them once we've double checked everything, and instruct them not to tell the students at any time who they voted for or who won. And then at this point, this would have been on last year, explaining the case. We talked to them about exhibits, any issues that we've run across, any clarifications that might have come in, and then things to be on the lookout for. We remind them the students cannot use anything outside of the fact pattern, including internet, social media, and then when we were in the courthouses, not to touch the judge's stuff on the bench. Remind them that stipulations are indeed part of the case. The Business Records Act is in there as part of an evidentiary issue. The teams are not allowed to make up facts and can only use the evidence in the packet. That includes the facts that are there and reasonable inferences from. We explain to them the unfair extrapolation prohibition, and that you cannot adversely call a witness from the other side, regardless of how their testimony might affect the case. The prosecution has to call their 3 witnesses, defense has to call their 3. And then we talked to them about courtroom artists that may be there. This year will probably be slightly different. This was the winner 2 years ago. We do not give them any critiques, follow them out of the courtroom so that the judge is the last one, and put everything together. And then we thank them very, very much for their services. We could not do that without them. That is generally the overview that we give the judges. The only thing that you did not see there would have been a basic brief or summary of the case. And again, that's more of a bench brief. It's not submitted to any of the teams and only to the judges for their use. We will often answer questions about the case when things come up from different trials, issues with, I think we had students one time wanted to use their iPad because it had their outline on it, reiterating there's no electronics, even if that's the only place they have their notes. We've had issues where we explain students perhaps with medical issues, they may have an electronic thing on their person that may beep. so that they know that that's out there and that there's, that's been approved and there's no issues there, or anything that we've seen that have come up when one team was marking on the exhibits and reiterating that's against the rules. We've changed the rules that you can no longer do constructive redaction. So we always remind them of that rule because many judges have been here many years and they fall back into that. But essentially anything that starts coming up, unfair extrapolation is one. We hear of a team that's unfairly extrapolating something, the judges are put on notice and they know to look out for it. Also put on notice if certain witnesses are wasting time or just to be on the lookout for it in general, and that we want them to count off for that, as that is not part of the case, that is not part of advocacy, that is improper gamesmanship. And to reiterate that it is an advocacy case about the facts that are in the trial. And with that, I believe that is the end of my slideshow. So a quick word on the technical aspects of the trial. It is going to be, we know for certain it will be virtual. And again, we're going to have a meeting later to firm up these rules, but I will just give you an overview of what we are anticipating of how this will work. Having done an arbitration on Zoom with dozens of witnesses and 20 some odd attorneys, we've discovered that the best practice is for your attorneys and witnesses to be in separate rooms. This prevents the echo and feedback issue. We understand that makes it a little weird that you're directing your own witness over camera, but it's no different than the cross you're going to be doing of the other side's witness. We anticipate that teams will have one camera on their lawyers. So the attorney that's questioning will be on camera, the attorney that is defending will be on camera, the witness will be on camera, and the judge will be on camera. Those four screens keep the screen from being boxed or cluttered. And then the students will change either positions, or if they have multiple cameras, can change turning cameras on and off. The defending attorney, the one that would be lodging objections should they want to, everybody will be on camera, that attorney will be on camera, and they will not be on mute. So they will have to practice being relatively silent and still. It is possible their fellow attorney might want to talk to them, in which case maybe they would mute, or they probably should mute, but we don't want them to be on mute because you're going to get the objection, it's going to get missed because they're not on camera. Just like anything else, you're going to have to practice with your students on how to make the online and the technical aspect seamless. One thing that we anticipate but have not decided yet is with respect to exhibits. We do not anticipate that students will have control and the ability to show exhibits on screen. There is just too much that can go wrong. We are exploring the idea of the judge having control over it. So if a student says, Your Honor, I would like to see exhibit 3, exhibit 3 would come up. Our concern with that is many of our experienced judges lack experience on Zoom, and to avoid technical disruptions, timing issues, it is possible that we will recommend that everybody have the exhibits in hard copy. So they can instruct the witness, please turn to exhibit 3. The judges will have exhibit 3, and they will then discuss that exhibit, including getting it admitted, etc. I understand that that means that people are seeing exhibits before they're technically admitted, but in reality, they have already seen them anyway. The one exception that we are discussing, and without going into specifics of the case, I'm sure you're aware that exhibit 1 is a map. To the extent that someone wants to point to areas on the map, we're thinking through that and how best that could work, but it is possible the students may have to describe it using colors and locations. We're practicing it with a student holding it up on screen. It doesn't look great, but I'll tell you that that is one of the areas that we're struggling with the most, is how to effectively use the exhibits such that it does not disrupt the court and is easier for the students to use. I will reiterate that you should ensure your students are savvy enough with the process and everything is up to date. Despite several emails that we sent that the students needed to upgrade the most current version of Zoom so that they had the ability to select their breakout rooms in the last meetings, dozens of students had not done that. While we probably are not letting students self-select courtrooms for the competition, just to ensure that nobody gets in the wrong courtroom, there may be additional updates that occur. And so you all should be very vigilant in ensuring whatever computer is being used, whether it's their personal computer, your school computer, is up to date on Zoom to avoid technical problems. We will have a protocol for, a student that gets logged off, Wi-Fi technical problems, but I would take this time before competition to stress test your internet, have your students wherever locations they expect to be, have you all on Zoom together to practice if there's any lag, to see what they look like on camera, to practice, objecting, which definitely will be new and difficult this year on Zoom. So I cannot stress enough the actual physical practice of this on camera to get the students as used to it as possible. Things will be different, but just like in law, as we're moving to these types of virtual platforms, the lawyers that learn it faster tend to present better. And I think it's no different for the students in this case. With that, I think that's all I've got. I'm sure there'll be other technical questions that I'm happy to answer what we anticipate and understand, but we're stress testing some of these various things to see how they work, and we'll have more firm commitments on it later. So again, I'm happy to answer any questions somebody has. I will not answer anything about the case. If you have clarification questions, that you have the process to submit those, but haven't answered anything else. Let's see, I've got one. How many cameras will we need to prepare our courtroom classroom for competition? So I think it's a minimum of 2. One for the room for the attorneys, one for the room with the witnesses. Because if your student witnesses are not being examined, then that camera will be off, it'll be the other witnesses. You could have up to 6 if you wanted to have 6, or if for whatever reason you were in 6 different locations. We toyed with the idea of having the timekeepers on camera as well, but frankly, it clutters the screen, and those poor students are just going to sit there on camera and hold up. So for timing, we anticipate the timekeepers will use the chat function to say 10, 5, 4, whatever it is. Again, that is something your attorneys will have to practice because they won't have that cue of somebody showing them the times. We probably will only have one timekeeper doing that so that you don't see 10, 10, 5, 5, 4, 4, and the other timekeeper will be just doing a check to make sure there are no discrepancies. Should there be one room for witnesses and one room for attorneys? Yes, I think there almost has to be because of the feedback issue. One computer, when it hears the other one, it just for practice, go into a Zoom meeting with 2 computers in the same room and you'll see what I'm talking about. We understand that presents issues with communications from lawyers to witnesses, and we are exploring ways to allow communications. Frankly, I rarely see witnesses and lawyers communicating even in trials, so I'm not sure that's a huge issue. But with respect to attorneys, if they're in the same room, we would probably advise them using notes, but we're looking into allowing them to use the chat function on Zoom. One, they have to make sure they're only sending it to their team, and 2, because it's something that we could have a record of. But that one will be slightly difficult as we're trying to figure it out. We understand that there's going to have to be exceptions. Coaches, we're anticipating not barring you from the rooms just to make sure that there are no technical issues. The rules will still be in place. There can be no coaching whatsoever during the competition. And we're anticipating that basically at the end of trial, we're going to ask every student to stand up and swear or affirm they received no help during the trial. And if we find out that there was, they will immediately be disqualified. So we're taking that very seriously. It is difficult to monitor in these times in this issue. So I just want to reiterate that do not take advantage of this process. And we are going to have the students affirm that they have not done that. Oh my, okay, I've got a lot more now.
I put in real quick and say, in terms of attorneys being able to communicate with each other, we're looking at, obviously if you're going to have a group text chat, on your phone, or you're going to be using the GroupMe app, obviously that would be fine. The reason we're still exploring those options because the chat could get a little cluttered, or you could accidentally send, instead of privately, you're sending it to everyone. And so, so just know we are taking that into consideration.
Yes. All right, so I think now I'm on Rebecca's a little confused on the 3 lawyers part, students competing against other teams or presenting the case as a team. It's both, actually. Your 6-person team, 3 lawyers and 3 witnesses present one side of the case against another 6-student team who is presenting the other side. You will prepare both sides of the case, as you won't know what side you are presenting until right before trial. But yes, you are presenting as a team, that you will prepare as a team, and then you are going against another 6-student team that is doing the same thing. New, is there a place where we go to see all the information on how this works? Yes, the Texas High School Mock Trial website provides a host of information on overviews, the fact pattern, kind of an explanation of how it works. There should be plenty of explanation there. If you have questions after that, you might ask other coaches just general how things work. And then of course, we're here to answer other questions that you might have.
And if they mean virtual mock trial on that question, so we've got a different set of virtual mock trial guidelines that have been sent to regional coordinators, and we're kind of just giving them the option to choose which way you want to go. Obviously, small regions are going to run differently than the bigger ones, and so we're giving regional coordinators that liberty to choose and kind of see what could work for their region. So, and those are not posted on the website along with the new competition rules. We're kind of still hammering that out before I post those on the materials page. So in case you're running over there to see if you're going to find that on the website, that's not there yet. But we're finalizing that now.
Yeah, and Vanessa, I see your question. Do we know competitions for sure on Fridays or Saturdays? Again, that is a regional coordinator question. I would anticipate the answer is yes, but every region will be different. How will a team know if a scoring judge is having audio problems or lags? So at this time, we are anticipating that the trials may only be scored by the presiding judge. And the reason for that, and I understand that is not ideal. The reason for that is we have 2 options. You can either have scoring judges who are on screen for the entirety of the trial, and now there are 3 more screens on camera. Alternatively, they then are off camera and scoring, but then the students and frankly us have no idea if they are paying attention or what they are doing. So we anticipate it may only be the presiding judge that is scoring, similar to almost a bench trial. That is not ideal. We're not thrilled with that idea, but given the technological issues with either having them on camera or having them off, it makes it quite difficult. So it's possible we'll have more, but it is kind of a hard decision on whether we want them on screen or we want them off, as both present issues. But to answer the question, if the scoring judge is on screen, you certainly should be able to see and hear them. And we'll have processes in place for the scoring judge to notify whoever is the administrator or coordinator of the Zoom meeting, because we'll essentially break people out into breakout rooms to act as virtual courtrooms, that somebody will be there with technological abilities in order to resolve any problems.
Our hope is that we would get enough, since we're doing this virtually, that we'll be able to get judges from just all over the place, and maybe from groups that we haven't been able to before. So that's definitely what we're hoping. We hope we don't have to do one judge panels. In terms of, if it's just going to be the presiding judge on video, then the scoring judges can have their video off. And, we just have to trust that they're they're listening and that they're engaged the whole time and watching the trial. If for some, in these guidelines and competition rules, we are working on have a section where what to do if a student's internet goes out, if a judge's internet goes out. And it all depends, we're going to have a pause and give people a chance to hop back on, give them a chance to hop back by phone, to try it out without their video. Maybe that helps with the Wi-Fi. Give them a chance to reset their modem and come back. But then, but always communicating to see, what, I'm not going to make it back. Then, there's protocol for that. If teams have a student that can sub in to take over a role for judges, if that judge just can't come back, then we will, handle the scores like we do in an in-person competition, because we do have rules as to, if we only have a 1 judge panel, if we have a 2 judge panel. And it's some extra math, but it's doable.
Yeah, I see Denise's questions, examples of what it should look like on Zoom. I anticipate that will be part of the technical discussion. Given your question, we may do a brief cross and direct of a fake witness based on last year's fact pattern or something, just so you can see what it probably will look like. But I think that is a good idea. Our region has not set a date for region competition. I would talk to Melissa about that. Should a coach be in a third room then? I think yes, to the extent the judge wants to observe on their own computer, that is probably best on a third computer, as you will get the lag problem if you're in the same room. You know, and I understand that logistically kind of starts to create some issues, but yeah, you will see that there are significant lag problems when everybody is on in the same room. And so that is why we're trying to work all that out at this time. Let's see. Surely I see, when will we receive that information? I'm not sure what that referred to. If it was about the technical, we're working on putting together. Oh, here we go.
Yes. Ms. Garcia had mentioned she had passed on information at the regional level. And I know the regional people, they're so busy because they don't just do mock trial, they do a lot of other stuff. So I have kind of been like, you know, can I get information? Can I get information? And I have my district meet coming up that I do, and I feel like I'm not ready. It's in a couple of weeks. And so I was just wondering, you know, how that's going to trickle down to my district.
Hey, definitely. I know Ms. Munoz, yes, JJ is very busy with everything going on, but I know he has a plan. I actually just talked to him on Friday, and he has a way of how he wants to do it. And so, but definitely, like I said, these guidelines are pretty much finalized. I think another reason I'm nervous about posting them is that you guys might look at these and think like, okay, well, which one are we doing? And I'm like, okay, well, that's up to your regional coordinator. But I may just go ahead and post them, and just so you guys can look over all the options and see how to run it. And Ms. Munoz, if you're doing your own district meet, then you can kind of do it the way you want to. You can you'll be able to look at those guidelines and see which way you want to do it, because there's 3 options.
Sorry, we just want to do it as close as possible to regionals, right. And you know, because that's going to be what's best for students and just fair across the board. So
in the guidelines, it's highlighted, just because I just looked at them. It's highlighted in the one that we recommend, which is probably what we will be doing in state. So you'll be able to see that, so you can go with that option.
Okay, thank you, Ms. Garcia. Appreciate it.
Thank you.
Okay, so I went through the rest of the messages. I think it's great. A lot of you are organizing scrimmages, which is definitely a great idea and certainly allowed. I just reiterate that we don't take into consideration any teams that you've scrimmaged. So it's possible you could see that scrimmage team, but it is absolutely, it's encouraged and certainly permissible to scrimmage. Let's see, can we have 1 or 2 cameras, computers on all 6 students with a tech person conducting mute and on-screen coordination? I think that's fine. You're gonna need more than 1 camera, because you will absolutely have to have a camera on the witness and the lawyer. And that's for the judge being able to see them separately, and also for opposing counsel. So I don't think it's not going to work to have the 2 of them sitting next to each other. One, it's just not going to look correct. And then the student asking the questions can't see the witness without turning. And then now we can't see it. So it's going to have to be separate cameras for witnesses and attorneys. I think if you have a tech person that can help with mute and things like that, I think that's great. Certainly something to practice. And we'll have more details on kind of who's muted, who's not, when we kind of go through the technical function.
And guys, something we haven't done before is that way, to encourage scrimmaging and more practice, I will send a list of registered schools. That way you guys can go ahead and contact each other and schedule scrimmages that way. Maybe I'll open something in a Google folder. Maybe there'll be like a Google sheet. You guys can put in your availability, something like that. But I'll definitely share team information. That way you guys can contact each other about scheduling scrimmages.
So I see a question about a wide camera that shows all students at once. You know, practically that doesn't work, because in order for the judges to see your students, they need to be close up. And again, with the facing each other by talking, it just doesn't work that way. If there's some reason why you guys can't do 2 rooms, then I think we can discuss, but you will want your students to be up close on camera, as that will almost certainly generate better points than someone who is very far away, harder to hear. You know, we anticipate that almost all of the trial will be done sitting, only because we don't want students standing and then they're delivering their opening statement like that. It's possible opens and closes might be allowed to do standing, but we haven't crossed that bridge yet. So once again, to practice, I've done several of these. It does take practice to find the camera and look into it, as opposed to looking at yourself on screen. So, it's once again, it's a presentation thing that students will have to practice. There are tricks, such as, putting a Word document up near the camera. If that's got notes or questions that you want to write, I think that's fine as long as it's yours. It's not, something from your coach in the middle of competition. I think having something on notes on the ground is fine too, if they want to look just like in real trial and then come back to ask the question. So it's going to take practice. I think I saw a question on, can there parent observers during the tournament? We're looking into that. If so, the parents would log in as just a pure observer into the Zoom room. We would probably set it so that their mic and video is permanently off, just to prevent any problems. So I would say that is definitely possible, assuming we can assure the no scouting rule. But yes, I would say that is possible, if not very likely. Let's see. We have a student whose parents don't want her to be in a room with other students. What would we have her in Zoom with her own camera so she turned for her parts? Yes, I think to the extent that a student is, for whatever reason, is isolated, then yes, they should have their own camera and their own computer. And if they are a lawyer, right, they'll just be turning their camera and mic off when it's not their turn, with witnesses and otherwise. But yes, I think that's somewhat of a good silver lining of at least this process, is that you can be in 6 separate places if you want. But I just would reiterate for, again, just practice, stress test the internet connection, making sure that, you're not having lag issues or addressing those if you have. But yes, that would be totally fine. As long as, again, the student is isolated and not receiving outside help, which again, we'll have them confirm at the end. Being that I am a coach and the tech, would it appear or come off as coaching? So that's the one issue we're working through about, in a perfect world, if we can assure perfect tech, we would keep the coaches out of the room with the students. That would help prevent any type of nonverbal or verbal coaching. I realize that that's not really possible. If you have a tech person, then they could be the person in the room, but it may be the coach is the tech person as well. So I would say we're anticipating that, yes, you'll be in the room to help with tech, seeing that most everything is on camera and audio. I think we would be able to figure it out if you were coaching, but just like in real law, I mean, a lot of this is going to have to be honor system of the coaches and the students not going outside the rules and not cheating. And we'll have everybody affirm if for some reason somebody suspects or another school is cheating, and we'll look into that just like we would normally do. But we understand it's not practical to leave the students by themselves in case something goes wrong. Can they be masked when 2 or more students in the room? So I've gotten this question a couple of times already. We are anticipating that the students, if they are on camera, I don't think they're going to be able to be masked. I think it is too difficult to hear, understand, and see the witness. I understand that obviously there's some social distancing issues. So we don't anticipate all 3 lawyers to be sitting right next to each other. We would anticipate the other lawyers being a distance away and not on camera. So to the extent that that works for the distancing, I cannot see a scenario where a masked student on camera is going to work, just from audio and to be able to see the students themselves. But we can look into it if there's really an issue. I can't foresee how that is going to work. The competitions usually during school hours or the weekend for planning purposes. They are usually on the weekends. There are sometimes on a Friday. Like state, for example, I think goes Friday, Saturday, Sunday, but it'll be up to your regional coordinators, but the vast majority are over the weekend. And yeah, I mean, during school hours, you could there's certainly practices or scrimmages, but again, some schools have done Fridays. State, we do on Fridays just in order to get everybody in. And then there are some on Thursday nights during state to accommodate some religious observances on Saturdays. Austin area, our public schools may not allow an unmasked in-person extracurricular activity. Will need to have every participant on their own camera. Correct. I mean, I think in the event that there are restrictions in, obviously Texas, we've got hundreds of counties. There's going to be different rules. You know, the solution there is 6 cameras and 6 computers. I understand that presents some issues. You know, school doesn't have 6, students don't. But you know, that unfortunately is a restriction that I'm not particularly happy with, but is kind of forced on us in this virtual platform.
And if I could add in, I coach a mock trial team. We were required by our competition rules to be, every student had to be in a separate room, and it worked fine. So I wouldn't be too concerned if the students do need to be in separate rooms for some reason. It'll still work fine. We'll figure, the rules will allow y'all to still communicate with one another. So just wanted to let y'all know I've done it and it's worked okay.
Yeah, and that will be something in process. I mean, certainly the rules can change tomorrow, they could change in a month, and that's something that we understand can happen, and we'll just have to address it at that time. But to the extent you have 6 computers with 6 cameras, I think it's a great idea to practice in that environment, at least as a backup if that is what occurs. But I understand that that's not possible across all schools and by design. I would look into, I would definitely start practicing your tech. If your school has a tech person, I would talk to them. You know, there's a number of ways of external speakers, using mics or headphone mics to reduce feedback. We're looking into the headphone mic thing. I think that's probably going to be okay as long as it doesn't cover the student's face too much so that we can see them. That definitely helps with feedback and some audio, because you definitely don't want the student to be quiet or we're unable to hear them. So I would just start kind of testing a lot of that now and practicing with it. But your microphone, your audio, ability to hear you, and the lag are things that are just really important. As it's good presentation, but we will have processes in place in case something goes wrong, because inevitably something will go wrong. Let's see, cameras can just be normal laptop cameras, right? Yes. I mean, I would take a look at what your student looks like on that camera. You definitely will want to practice and look through lighting, background. Like for instance, my background right now would not be advised. It's very busy. It's the camera in my office. If you have a window, then you get lighting in a weird way. I think a school room or any room that has a basic white wall behind it works. I would not recommend virtual backgrounds, as that is even more distracting than perhaps what I have behind me. So you might want to be on the lookout for areas that will make presentation a lot better, because you just don't want to be distracting. That's not something that would, is on the scorecard, but just like in real life, presentation can add or subtract points where they go.
I would recommend finding that place as early on as you can where you'll compete.
Yeah.
And then, as Taylor suggested, figure out the acoustics of the room, the lighting, all of that good stuff, so you don't have to be panicked about that on competition day.
I see a question from Kirk. Will there be a pre-written script for entering exhibits on Zoom once the presentation on screen sharing issue is resolved? Probably. I mean, we don't release a script on how they introduce evidence in real trial, but we will provide, hey, here's the process. Your Honor, may we see Exhibit 3? And then, Your Honor, can you please take down Exhibit 3? Yes, we will give you kind of some instructions on how that works. We won't give you a script on how you actually admit the exhibit, but yes, we will give you some procedural things to make sure everybody is consistent if we do the judge showing the exhibits versus the hard copy, as both kind of present benefits, so we're still kind of trying to work that one out.
I'm sorry, I do have a question on the background.
Sure.
Could it be a digital background, but just plain background? The reason why I'm asking is because as of right now, our students are at home
Right.
virtually learning, and they might not have the accessibility of that uncluttered room or uncluttered background that maybe will be better for them.
Right. So I think, I guess I would just say, like, test it out and see what it looks like. If it's a plain color, white probably, or beige, I think that's probably fine. You just would want to look at when they move, when they're talking, do you start to see kind of like a weird static glare or electronic glare? That can be distracting. And again, this is more, it's not illegal or improper, right? These are just tips to help you with presentation for scoring, because it inevitably will factor in, whether subconsciously or not. And you want your students to present well. It's just like having the proper suit, knowing how to stand, knowing how to look, make eye contact, etc. But I think a single color would probably be okay. I would practice with it and see what it looks like. Does it kind of fuzz at certain times, or does it do something weird when you move? But generally, I think the concept is okay.
Do
Thank you.
practice to see if it takes up a lot of, sometimes the backgrounds take up more bandwidth, so it'll
Yeah.
slow down your Wi-Fi. So do take that into consideration as well. I don't know, but yeah, definitely. I know it might be hard to find a blank wall in your house to be in front of, and so.
Yeah, that's a great point made by Christopher in the chat, is if your students have pets, if there are noises that are going to be in the background, try to minimize that as much as you can. I know that we're all doing the best we can, but to the extent you can avoid having background noise that might be a distraction, that's going to also be helpful for presentation.
Yeah, if your students are just, for example, at school and they're in a room, you're going to want to have a sign outside, do not disturb, competition in progress, things like that. I think it's inevitable that somebody's dog or cat's going to run into the room, but you just want to take every precaution you can to minimize any of those distractions, because one, it'll disrupt the trial, and two, it might throw your student off the game if somebody random happens to come in. And that'll happen with practice. Practice these scenarios of, I have to go into a lockdown room or with no distractions and no interruptions for 45 minutes or an hour, etc. They are not going to stand for objections. I think that is almost certainly going to be the case, just because you want your student to be filling most of the screen, right, with their face, in order for them to see. And so if you stand for objections, the cameras are going to get moved off. We're working on the process for that. I'll tell you what I anticipate right now. The objecting attorney will be on screen at all times and unmuted, to avoid them missing an objection for mute. That, I suppose, that could change, but I anticipate that the defending attorney, or the one that would make the objection, be on camera. And then when they're going to object, doing something just to draw attention to themselves. Your Honor, I'm sorry, but I must object for relevance or hearsay. I think that will help the judge, who's going to be looking at all four screens, to draw the attention over there. It's going to take practice. It's awkward to interrupt on Zoom when you need to make the objection, but I think if you just, I apologize for interrupting, Your Honor, I object to hearsay. You want to do that before the answer comes out, otherwise you essentially waive the objection. Clarify the special power matching guideline for this year. I don't have any information on that. That might be a Steve question. I know that we likely will pre-draw everything in the first round, but we do that already on a randomness. But I don't have, I'll mark that for Steve as a question. I know that was in discussion, but I don't think we have any clarity on that.
Yeah, we haven't worked that out yet, because we need we're also working out on schedule, seeing how 3 trials is going to look like, how 4 trials is going to look like.
Yes.
I feel like even looking at 3, we're probably splitting that off into 2 days just because of Zoom fatigue. And I just want to remind everyone that power matching, we always do it at state, but it's up to your regional coordinator as to whether they do that at regional. Because if you have a small region, then there's not really a whole bunch of point in power matching.
Yeah, so Sophia, power matching, what that is the first round is randomly assigned. Teams are matched up by letter in a random fashion. So let's just, for sake of argument, say there are 12 schools competing. So you'll have 6 trials. After round 1, there will be 6 winners like 6 teams that are 1-0 and 6 that are 0-1. The 1-0 teams will then all play each other. We will match up those 6 teams that are 1-0 random. Well, it's not random. It's based on your rank, right? So the top team would be the one that got the most points and the most ballots. And then they are matched with basically the 6th ranked team that would have also been 1-0, but got the least number of points and the least number of ballots from a winning team. 2 versus 5 and 3 versus 4. The teams that are 0-1 do exactly the same thing. After round 2, well, I'm now realizing that 12 is a bad example. It should be 16. But in any event, after round 2, the teams that are 2-0 will then be matched against each other. Teams that are 1-1 matched and teams that are 0-2 matched together. The purpose of this is so that a team does not essentially get a extremely easy schedule compared to another team. A team could theoretically play 3 teams that ultimately ended up 0-3 if it was just random, versus a team that also went 2-1 but ended up playing, teams that also were 2-1. So that's the purpose of the power matching. And it does not, I think there's maybe a misconception, but there are plenty of instances of teams that start 0-1 that are able to climb back into a top position at 2-1. So it's not a process where you lose that first round, it's over. There are plenty of instances where the teams that move on are the undefeated teams, but it's the most fair way, and it's a process used in many of the main mock trial competitions. To confirm, students be unmuted when they are competing, correct? Yes. The students that are participating, so the 2 lawyers, so the one that's doing direct and one that's doing cross, the witness, and the judge may be on mute, just because he or she will only be speaking when asked, by way of objection. But your student should be off mute the entire time. And really, the purpose of this is to avoid the "I'm sorry, counsel, you seem to be on mute" issue. I suppose it's possible if a team says that they've got it under control and they know how to mute and unmute well, we can look into that, but it's to avoid that, because especially on objections, you're going to miss the objection if you're on mute and we don't realize it in time. As for mute, difficult for my students, especially since they're multifamily housing, and don't want students to be docked because they're unable to control their surroundings. Yeah, and that's one of the hardest things about this setup, right? Is there are circumstances that are extremely difficult to control. When they are not presenting, they certainly are on mute and off camera. So let me just make sure that was clear. That if you're not directing or crossing the witness, or you're not the witness that's being examined, you're off camera and you're off mute. But when you're on, you are going to have to be, because if you have noise going on in your house, when you unmute, it's going to be there anyway. So, you might look into scenarios now of ways to isolate rooms at the school that might be able to be used. So I would take this time now to start practicing and preparing for that, because it's an unfortunate issue, and frankly, it sucks the way that this process has to be, given just kind of the variety of resources and locations that people are in. But it's going to have to be a quiet place, or it just frankly won't work.
And I just want to say that we're definitely not looking out to dock points from anybody.
Oh, agree.
And reiterating to judges too, that especially in the situation that we're in, always going to be consistently reminding them that, please don't dock points if somebody accidentally runs into the room, if Wi-Fi drops, if dog barks, mowers showed up. Yes, you guys, we're definitely not looking out to dock points off anyone. We're going to be as flexible and as just as much grace as possible.
Yeah, and the judges will definitely be instructed. It's one of the reasons why we definitely don't want the students being able to put the exhibits on screen, is that there will be schools that have a vast technological advantage, right? And are using things that make the exhibits look cool and are zooming in on it. They wouldn't be able to mark on it. And we don't think that that's fair. And so we want to put everybody on the same page. I'm leaning toward hard copy exhibits. just because I think it's the easiest. But I recognize as one of the authors of the fact pattern that presents a problem, I think, with Exhibit 1. But we're looking into that. But yes, the judges will be definitely instructed that there is going to be a difference in quality, backgrounds, et cetera, and that's not a purpose. That's not a reason for points. And yeah, if somebody drops off, like they're not getting docked. Everybody understands. Enough lawyers have been on enough Zoom calls that I think they understand that even with, even on my firm's super Wi-Fi, I have had issues because it's just inevitable. We're almost at the 1:30. I don't want to hold anybody any longer than they want. I'm happy to stay and answer more questions. But Melissa is recording this to the extent that you have a conflict or need to leave at 1:30. Please feel free to do that. We also did the clinic earlier today. All of those should have been recorded and were being downloaded. And so to the extent your students attended one, but then want to see another one or want to go rewatch, those will get provided to you at some point.
Taylor, I'm a horrible typist, so
that's okay.
I'll ask this question. Steve earlier was talking about trying to limit the screen to six people, so that way the faces wouldn't be too small,
right,
and we could see that. My question was twofolds. One was I assume with 6 that would include the timekeepers.
Yeah, I think we're not going to include the timekeepers. He and I have been in discussions with it, and to be honest with you, I've just kind of decided that I don't think it makes sense to have the poor timekeepers on camera for the whole trial, just sitting there holding up numbers when they could just type it in. And I think that allows the 4 screens to be a lot bigger when you are in gallery view. We're going to instruct the judges to have it in gallery view so they can see all the participants. To the extent your students want to turn off their self camera, so you can have the ability in Zoom to turn off, like I can see myself on screen. You have the ability to turn that off. If you wanted to turn that off, I suppose that's fine to free up the space. I suppose it's fine if you wanted to try speaker view, but you have a little bit of that. I think it's going to be a lot easier to have it in gallery so you can see everybody at one time. But yeah, I don't think to me, it just doesn't make sense to have the timekeepers on there because they still have a purpose to monitor the time and use it in the chat function, but I just think it would be really hard for a student to just sit there and they'd be on mute, right? But just to sit there for 3 hours.
That was my second part, is how much, assuming that there'll be 6 different rooms,
right?
How much allowance will we have if we wanted to just does everybody needs to be logged on that at the same time, or can, let's say, a second attorney joins the Zoom when it's their turn, so that way only there be the one on there, so not all attorneys have to be there at the same time, or all witnesses have to be there at the same time?
Well,
be something to consider.
Yeah, they should be, if they're in 6 different locations, they should be logged onto Zoom throughout the trial, just because they may not be able to anticipate when they're going to go. But yes, if the attorney, right, so like the attorney that is giving open, the other 2 attorneys they wouldn't be on screen, and they would be on mute, and they wouldn't have to work that. If for whatever reason you have all 3 attorneys in one room, you could conceivably do it with 1 computer and 1 camera. They would just kind of rotate the seats. The problem with that is that your other attorneys then probably don't have a great view of what's going on in trial. That might work, but I think that presents its own issue. But that may be the best feasible way of doing it. And yeah, they would be off, they would be away at distance and off camera. That way they're not on top of each other for distancing purposes. But definitely would be logged in the whole time.
Yeah, thank you. Thank you, Melissa.
Let's see, I see Elise, a robotics contest requiring every team to have an on-site trusted agent to manage the camera. Maybe that would work for the exhibits. I mean, I think in a perfect world that might work. I just don't know that every school is going to have that resource available to them. We really want, again, to kind of normalize any resource advantage that one school may have over the other. And I'm concerned that if I allow the judges to put the exhibits up, that there's going to be issues. And so now some schools are having a great time because their judges know what's going on, and others are having a lot of technical difficulty, that it makes me want to lean toward the hard copy exhibits, because then really nothing can go wrong with that. You all already print off copies of those. The judges will have those. And I think it makes all of the competitions more representative and consistent. I mean, one issue we have there is the notebooks that the witnesses and everybody will have to have the exhibits and the fact statements in case of impeachment. That sort of flies in the rule of the witnesses can't take anything up to the stand, but I think it's going to be pretty obvious if the witness is reading from their fact statement, because they'll be doing this. So that's really the only concern we have, but I just don't think it's a big one. So we haven't made that decision yet, but I would lean toward it's going to be hard copy exhibits. If a lawyer is using an exhibit, will they have screen sharing rights? No, that's the point of this, is that alone presents so many problems and potential issues that we just cannot have the students screen sharing, not to mention that there could be advantages schools could have based on their technology. So the process would likely look like, Your Honor, I'm now going to refer to Exhibit 3. Witness, whatever, Mr. or Mrs. Witness, turn to Exhibit 3 in your notebook. Yes, what is that? And then have them describe it and go through your process of, Your Honor, now I move Exhibit 3 into evidence. Objections, whatever, Exhibit 3 is admitted. All right, now looking at Exhibit 3, can you read where it says yada, yada, yada? That's going to take practice. If you're junior coaches or lawyers, there's issues about creating a record when you're pointing and talking to things. So that's something your students will have to work on. Can you look at the third paragraph from the bottom where it starts with the word sometimes, okay, in order to help direct not only your witness, because hopefully your witness knows where you're going because you practice it, but also the judge and any scoring judges and opposing counsel. But we definitely probably are not going to have to do the whole, I'm showing the exhibit to opposing counsel, because everybody's going to have the same exhibits. It's likely you can skip all that, but just direct the judge and the lawyer to the exhibit and go through your standard process. Lawyer, how do you verify the exhibits are unmarked? Yeah, I mean, Christopher's right. I mean, there's going to have to be a lot of honor system involved in this. The problem with that is if you did it virtually, the students can still have a marked exhibit in front of them anyway. So there's just going to have to be a lot of honor system on this. I suppose if a side believed that the witness had a marked copy, they could ask, like, Your Honor, we think the witness may have a marked copy. Can the witness show it on camera? I think that would be your resolution if you just really thought that they were. But yeah, it's another, yes, all the judges will have copies of all the exhibits. And I anticipate it will look like a small notebook. I mean, I have mine that I put together, but for them that will be tabbed, if they don't tab it or somehow we get it to them tabbed, 1 through 12, however many exhibits there are this year, and then A through F or some other tab that identifies the fact statements in case there is an impeachment. But the judges all typically have a copy of the fact pattern. They'll have the stipulations in case anything like that comes up, and the rules in case somebody needs to direct them to the rules for whatever reason, as well as the rules of evidence, I suppose, if they wanted that as well. And again, we'll solidify a lot of the technological stuff once we've stressed. We just don't want to make some rules now that we then discover later are unworkable, and you've spent a month under those guidelines and have to change. So that is why we're being very deliberate in putting this together. And hopefully, and I don't think it's running into your prep time. I assume likely right now you're still reading, analyzing, and dissecting the fact pattern, and putting together, themes, theories, objections, etc. but we endeavor to have you answer, shortly. Could witnesses use headphones to keep feedback down? If they were in the same room, I think that's possible. Again, they're going to have a separate camera. The witness, it just is unworkable to have the attorney and witness on the same camera. So I'm almost certain that works, because in our arbitration, opposing counsel, all of them were in some big conference room and all had headsets on. So there wasn't a feedback issue there, which makes sense, because the feedback comes from one computer hearing the audio from the other. And so if it's in a headset, then that shouldn't be a problem. Obviously, you're going to have to find headsets that work and sound okay. But that would be a solution if, for whatever reason, you wanted all 6 of your people in the same room. I would say that I don't think it's going to be feasible for your attorney to be able to see your witness's face other than on screen. I mean, maybe they could see it over screen, so I would just practice it by looking at your witness on screen. But yes, I think the headphone things would work. In fact, I know that they would work. You would just have to test it out to make sure that you're not getting essentially electronic feedback as opposed to audio feedback, such as if they were Bluetooth or otherwise wireless. I know I've had issues with that in my own office with my iPods. So again, you're just going to have to, everything you guys have will just have to be stress tested as much as possible. That's a great time for scrimmage, just kind of run through any issues with those as well, in addition to practicing actually cross-examining over screen, etc. All right, well, I'm happy to answer anything else. Otherwise, we'll send you guys on your way. Again, be on the lookout for copies of the recordings of this and the clinics that your students may or may not have attended. And then the technological guidelines and kind of rules that, again, we're working on. And I promise to get those as soon as we can kind of get those nailed down.
I'll have draft just stamped on it in big old letters, just so everybody knows it's fluid.
What is?
It's where the guidelines and the things as we start setting stuff
Yeah,
out,
I mean,
I
just wouldn't rely too heavy on it. It may change.
Right.
I'm actually not sure I've seen it yet, but I've been in communications with Steve about a number of issues, including the 4 versus 6 cameras, the timekeepers on camera. But I just cannot have that. Witness pre-trial introductions will be problematic. I assume that's probably referencing the whole, like, I'm going to have all my witnesses introduce themselves. Yeah, I hadn't thought about that. I mean, I'm not a huge fan of that process anyway. But that is something to think about.
I have seen mock trial competitions that have done it, but again, it's that coordination. It's kind of like, everybody standing at a certain amount of time. You already practice with your kids in terms of who introduces themselves first and who hands it from the attorneys to the witnesses.
Right.
And again, it's going to be that coordination.
I think that's right, but I had not thought of that either. But that's good. Okay.
Matt, I see your questions about naming themselves. We're going to give protocol for that, but there's going to be a very specific naming protocol, especially if you saw how we have to send people to their breakout rooms. It's going to be very strict on how we do that.
Yeah, their name certainly won't be their own name. It will definitely be a school. Well, sorry, I didn't mean their own name, not the school name, right? But it will be a school, and then likely role, and then their real name. They're definitely going to lead with their school letter, because that will help us push them into breakout rooms. Because you can write a very long name into Zoom, but then in the breakout room selection thing, I can only see so many characters, which I learned the hard way. So that's why your letter will be first. And if anything, it actually will be very helpful for the judge. They will know exactly who's talking, and exactly, for purposes of best witness, it should be a lot more seamless. All right. Well, again, if you guys have questions in the meantime, feel free to reach out to Melissa. Clarification questions, use the process on the website. But I hope you guys are enjoying the fact pattern. And we look forward to the virtual competition. I still think it's going to be great. It will be different. But we know other competitions have used it, so it does work. It is feasible. It just may take a little bit more practice and effort than we're used to. but we're looking forward to it. So thank you guys very much. Have a great rest of the day.
Thank you, everybody. Thank you so
Yeah.
much.
Thank you. Bye-bye.